Hi, welcome back to my YouTube channel. If you haven't checked out the previous video, please be sure to do so. And for those of you who are tuning in for the first time, my name is Ana Fernandez. Thank you for checking out my YouTube channel. These videos, I love doing them. They're directed to people that want help, need help, want a better understanding of family law cases, specifically in Florida. So we're going to continue talking about the new alimony reform in 2023. Now, if you didn't check out the first video, definitely check that one out, because there we went over the change that pretty much has the biggest impact, which is not having the ability to ask for permanent alimony. That changed July 1st. Governor DeSantis signed that bill June 30th, end of business day, which was, I believe, either a Friday, technically Saturday. In any case, came into effect on July 1st. We're not even midway through July, and I've received a ton of questions. So I'm happy to go over some of the concerns that people are having. Again, check out that other video. Permanent alimony is no longer in effect. So if you had your case pending or you haven't started your case, it's too late to ask for permanent alimony. If you do have an order that awarded you permanent alimony in the past, or you have an agreement, then that's not going to be affected. But in this video, we're actually going to talk about cohabitating. So one of the major changes also was that now Florida, if let's say you get married, you get divorced, and you have an award for alimony. Now, alimony is modifiable in the sense that, remember, you have to have the need, meaning that one of the spouses needs support and the other spouse has the ability to pay, right? So let's say we meet that standard, court enters into an order, gives me alimony, awesome. So let's say now, a few years pass, alimony, let's say it was awarded to me for a number of years. Let's say it was awarded for me for 15 years. I get divorced, now I fall in love, and hey, I don't want to get married because statutorily, it's always been in the statute that if you get married and you're receiving alimony, then you're no longer, it's modifiable in the sense that you can, if you're the spouse that's paying, you go to court and you say, look, sometimes you don't even need to go to court because it's usually or typically included in your marital settlement agreement or in the order that upon remarriage, the necessity and the requirement of having to pay someone alimony is automatically terminated. So let's say now I don't want to get married because I'm going to lose my alimony and I don't want to do that. Well, the statute was now changed that instead of it just being strictly to once this other person gets married, then alimony will terminate. Now it's if you start cohabitating, meaning that you live with somebody that is financially supporting you or supporting your needs, then the person that's paying alimony now has the right to modify it to terminate alimony. It's very important because before I have seen it in my practice where the person that was receiving alimony would, I'm not even lying, will wait until the month that it's going to expire to then announce, oh, we're getting married. So it's a lot of people used to do it because they would benefit from it. But now if you're receiving support, if you're living with someone and they're supporting you, then the person that was obligated, your previous spouse that was obligated to pay alimony, is no longer going to be required to do that. There are other changes that have to do with how you can modify it. Another one is courts now will consider retirement as a reason to change it. So let's say I'm receiving alimony and I never remarried, but now the person that's my ex-spouse that was paying for my alimony is now going to retire. Well, the way that the legislature looked at it is, we're not going to force someone to work forever just because they have to pay alimony. So if they reach the age of retirement, there are certain factors that the court's going to look at, like the desire to continue working, and the professions, and certain things are going to be looked at and are going to have requirements. Courts are now supposed to, or they've always supposed to, but now specifically it says it in the statute, you have to make findings of facts. So now it's not, they're gonna dive into your case, they're gonna look at all the facts, and they're gonna make a determination based on that. And it's all of that is gonna be included in the order. So main takeaway is you can now modify and terminate alimony, not just when you're married, not when the receiving spouse gets remarried, but now when that person is now in a relationship that is, they're supporting that person, like the relationship that they're in, they're cohabitating with them and they're having their needs met and being supported. Or I'm the paying spouse and I want to retire, like I'm 65, I think it is now, to retirement. The courts will look at that now. So we'll continue these videos. If you have any other questions, though, doesn't have to be about alimony, but this is the big one, at least for July. Please shoot them my way. I love making these videos and I love to hear from you. So again, Ana Fernandez, if you need anything, we're here.